everyone, welcome to iExamBee. I'm Neha, your law faculty at iExamBee's LegalBee. आज मैं इस वीडियो में कंटिन्यू करने वाली हूँ हमारा mock test series discussion with respect to the Contract Act. So we'll be taking up the mock test with respect to certain other aspects under the Contract Act. But before that, let me remind you that do remember to subscribe to our channel and press on the bell icon so that you can stay tuned and stay updated. अगर आपको कोई भी questions हो, queries हो या कोई भी guidance आपको चाहिए, आप हमें contact कर सकते हो through this email ID or you can also give us a call on this number which is displayed on the screen. इसके अलावा आप हमारी वेबसाइट को भी जरूर विजिट करें जहाँ पे कि आपको बहुत सारी इन्फॉर्मेशन मिल जाएंगे with respect to the various competitive exams. So do remember to stay tuned and stay updated. Today under the Contract Act we will be discussing the various mock tests, the questions related to contingent contracts and the performance of contracts. So if we talk about contingent contracts को हम क्या simply समझ सकते हैं, ये conditional contracts होते हैं. And why are they conditional contracts? Because the performance is dependent upon the fulfillment of certain condition. However, अगर on the other hand अगर हम absolute contracts की बात करें तो वहाँ क्या होता है, the performance is not dependent upon the fulfillment of certain other conditions. So contingent contract जो है simple words में अगर हम समझेंगे तो वहाँ पे performance जो है तभी करेगी पार्टी जब कुछ conditions जो parties अभी किए हैं वो fulfill होंगे तब. Now moving on to our very first question of discussion for today is a contingent contract is a contract to do or not to do something. So it could be either the party will be doing something or will not be doing something if some event collateral to such contract. So collateral you can also simply understand secondary. So a contingent contract is a contract wherein the party will either do or not do something if certain conditional or collateral or secondary thing with respect to that contract, and you can see the various options are does happen, does not happen, shall not happen, may not happen, either A or B, and the correct option is either A or B does happen or does not happen. So either that particular condition will happen or it will not happen. Based on that the performance is there. So section 31 में इससे related provision आप देख सकते हो. A contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. The second question for discussion is contingent agreements to do or not to do anything if an impossible event happens are void. So impossible event that happens are void when. So you have the various options and the correct option is E, whether the impossibility of the event is known or not known to the parties at the time when the agreement is made. So contingent contract with respect to doing or not doing anything, if it is with respect to any impossible event, they will be considered to be void. चाहे पार्टी को उस impossibility के बारे में पता था या नहीं पता था at the very time when the agreement was entered between them. Section 36 में आप देख सकते हो इससे related provision है which mentions agreement contingent on impossible events. So contract act mentions कि कोई भी agreement contingent है अगर कोई भी impossible event में, so it will be considered to be void. It does not matter whether the impossibility of the event that was known or not known to the parties when the agreement they were making or at that particular time when the agreement they were entering in. Question number 3 is talking about if there is an alternative promise where one branch is illegal, then what will happen? And you can see the various options are the legal branch alone can be enforced, the illegal branch might not be enforced, either branch may be enforced at the discretion of the parties, the either branch may be enforced at the discretion of the court, the entire promise is considered to be an illegal promise and thus void, and the correct option is A, the legal branch alone can be enforced. Section 58 is a related provision provide करता which mentions alternative promise one branch being illegal. In the case of alternative promise one branch of which is legal and the other is illegal, the legal branch alone can be enforced. So as much as the part of the contract which is legal and can be enforced, that can be taken ahead by the parties and the illegal will not be enforced obviously. So the legal branch alone that can be enforced. And the very next question is a contract to do an act which after the contract is made becomes impossible or by reason of some event which the promisor could not prevent unlawful, then in that case what will happen? You can look at the various options over here and the correct option is D, becomes void when the act becomes impossible or unlawful. Section 56 which is very important section which is basically talking about the doctrine of frustration under the Contract Act. Although that particular term of doctrine of frustration is not used under the Indian Contract Act, however it is talking about that. So section 56 क्या mention करता है? Agreement to do impossible act, contract to do an act which afterwards become impossible or unlawful. So contract to do an act which after the contract is made, जब contract में parties enter की थी तब ऐसा नहीं था, but later on it becomes impossible or it would by the reason of some event which the promisor could not prevent becomes unlawful. So in that case it will be becoming void when the act becomes impossible or unlawful. So when the contract becomes impossible or unlawful, it will be considered to be a void one. Now question number 5 talks about what are the consequences of recession of voidable contract as per the Contract Act. So यहाँ पे recession का मतलब क्या हो जाएगा? Unmaking of the contract and all. So what will be the consequences of recession or unmaking of the voidable contract as per the Contract Act? And the correct option for this is E, that is both B and C. What is B and C? Other party need not perform any promise therein contained in which he is promisor, and the party rescinding a voidable contract shall, if he has received any benefit from the other party to such contract, restore such benefit so far as may be to the person from whom it was received. Section 64 is talking about, and it mentions that the other party will not be required to go ahead and perform any of the promises that are contained in that, and where he is a promisor, and the one who is rescinding the avoidable contract is required to give back if anything he has received or any benefit he has received from the other party. So he'll be restoring or give back that particular benefit to the person from whom it was actually received by him. Now the very next question is question number 6, which talks about what is the obligation of a person who has received advantage under void agreement or a contract that becomes void as per section 65 of the Contract Act, and the correct option is D, which is either A or B. So what is A talking about? The person is bound to restore the advantage so received, and the person is bound to make compensation for it to the person from whom he received it. So section 65 बोलता है obligation of person who has received advantage under void agreement or contract that becomes void. So when an agreement to be void or when a contract becomes void, then any person who has received any advantage or benefit under that particular agreement or contract is under an obligation to restore it or to make compensation for it to the person from whom he actually received it. Then question number 7 that mentions if the parties to the contract agree to substitute a new contract for it or to rescind it or to alter it, then what will be the situation? So the various options are original contract may be performed, original contract need not be performed, original contract remains valid. Although parties may enter into another contract, original contract is non-extinguishable. Parties have the discretion to decide upon the same, and the correct option is original contract need not be performed. Section 62 is talking about what will be the effect of novation, recession and alteration of a contract. So you need to be aware of all these terms कि novation का क्या मतलब हुआ जब एक नया contract जो है place में आता है in place of the old one, or if there were parties to the contract that changed, then recession क्या हो जाएगा, cancellation या termination of the contract हो जाएगा. Alteration मतलब certain terms or conditions जो है उसमें changes लाएंगे, amend करेंगे. So you need to be clear of these concepts or terms also. And if the parties to the contract agree to substitute a new contract for it or to rescind or alter it, the original contract need not be performed. Obviously अगर new contract ही old के जगह पे हमने replace कर दिया या फिर parties कर दिया या फिर terminate कर दिया contract को या फिर certain changes कर दिए terms में, then in that case जो original था उसका कोई existence नहीं रहेगा. Original contract का performance जरूरी नहीं है करनी. And so the new one which has replaced the original contract that needs to be performed. Now moving on to our question number 8, which says where should the payment be applied in case the debt to be discharged is not indicated as per the provisions laid down under the Contract Act. So how that particular payment has to be appropriated in case जो debt discharge करना है उससे related payment has been made, but how that has to be applied that hasn't been indicated. And the various options you can see, and the correct option is E. Creditor may apply it at his discretion to any lawful debt actually due and payable to him from the debtor. Section 60 बोलता है application of payment where the debt to be discharged is not indicated. Moving on to our 9th question, that is what is the effect of promisee accepting the performance from third person? And the correct option is he cannot afterwards enforce it against the promisor. So once he has availed of what the performance of the promise from a third person, then later on the promisee cannot go ahead और वो demand नहीं कर सकता है या he cannot basically afterwards enforce it against the promisor. Section 41 इससे related provision provide करता है effect of accepting performance from third person. When a promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promisor. 10th question for today's discussion is when two or more persons have made joint promise and if any of them dies, then who will perform on his behalf. And you can see the various options over here. And the correct option is C, both A and B. That is, his representatives will be doing and the surviving promises will be performing the obligation. Section 42 is talking about the devolution of joint liabilities. When two or more persons have made a joint promise, then unless the contrary intentions appear from the contract, all of such persons during their joint life, so when they are alive, all of them will be jointly, and after the death of any of them, their representative jointly with जो भी surviving होंगे promisers उनके साथ, and after the death of the last survivor, representatives of all of them jointly will be fulfilling the promise. So with this, we come to an end of our today's video's mock test series discussion. Do remember to stay tuned so that you can avail the benefits of these series which we are taking up for making your preparations easier.